Assalamualaikum warahmatullahi wabarakatuh. We are group 15, where consists of 5 group members. First, Daiyana Danisha binti AZMI. Second, NURI NABILAH binti SAFIAN. Third, NUSAIBAH binti ISMAIL. Fourth, ATHIRAH binti Muhammad AFANDI. And fifth, SYAHIRA binti SUHAIMI. And we are going to explain about the legal framework governing cyberbullying among kids in Malaysia with comparative analysis of other countries' approaches.
Hi and Assalamualaikum. I'm ATHIRAH. I will be presenting the introduction section. First off, we all know that as technology evolves, the internet has gotten the top priority for almost all individuals, especially the Gen Z. It is a borderless site that people can simply access to almost everything just at the tip of their fingers. The existence of advanced technology cannot be denied that it gives a whole lot of benefits to people as it is people's work. But just like other things, it also has its cons. It may be a dangerous place to be till it can even create a crime. It has created new opportunities for people to commit heinous acts while disguising their true identities, and this is what we call cyberbullying. Cyberbullying is not a new phenomenon, especially as the world of technology advances. It is the act of harassing another person using technology as the weapon. This includes the transmission of vulgar or threatening text messages through mobile phones or the internet, such as on emails, blogs, social medias, and etc. Social media sites like Instagram, Twitter, TikTok or Facebook, and etc. are the sites where users, specifically the youngsters, often visit and suffer from cyberbullying. It has reached to the point of where a number of victims faced with severe problems such as trauma, depression, or what's worse is suicidal. For a record, a reported case of a 20-year-old girl committed suicide due to receiving a hate comments on TikTok. Due to that, it has been regarded as a criminal offense and there are legal consequences if one commits the offense. Although it might be difficult to bring a legal case against some forms of online bullying and abuse, many countries and governments are drafting new legislation or revising current legislation to include digital abuse and harassment in the online environment. Therefore, our group will be discussing the legal framework governing the cyberbullying issue in Malaysia, as well as reviewing a comparative analysis of approaches between selected countries of Asia.
Next, I will continue for Malaysia legal framework on cyberbullying. In Malaysia, up until now, there is still no explicit legislation regarding cyberbullying. Nevertheless, there are several existing laws that regulate online activities, which are the Communications and Multimedia Act, Evidence Act, and the Computer Crimes Act, and also the Penal Code. First, the Communications and Multimedia Act (CMA) has provided under Section 233 that deals with the improper use of network facilities. On the other hand, Section 233 subsection 1 of the same Act covers the punishment under this section, where it stated that if a person found guilty under this section, the offender faces a maximum fine of 50,000 or a maximum sentence of 1 year in prison or both. The use of this section can be portrayed in the case of PPE vs Rutinin bin Suhaimin, where the accused posted an offensive comment on Sultan of Perak homepage online guestbook and was charged under Section 233 of the CMA. Next, the Internet Publication under the Evidence Act. For this Act, the section that mentioned regarding online activities is Section 114A, and it holds service providers more accountable for the activities of their consumers. This indicates that if someone uses another's name or photograph, the genuine hack owner may be held accountable for any information uploaded. The application of Section 114A can be seen in the case of Ahmad Abdul Lawan PP, where the accused was found guilty of posting insulting comments on Facebook under the pseudonym of Zuliahya. Third, Malaysia's existing framework on cyberbullying is the Computer Crimes Act (CCA). In this Act, Section 3 specifies that a person is guilty of an offence if he causes a computer to perform any function with the aim to secure access to any program or data kept in any computer, and he knows at the time he causes the computer to perform the function that the access he wishes to secure is unauthorized. Furthermore, Section 4 stated that a person shall be guilty if he commits an offence referred to Section 3 with intent to commit an offence involving fraud or dishonesty or causing injury as defined in Penal Code, or to facilitate the commission of such an offence by himself or by another person. Both of these sections also did not refer to any specific preference of offences relating to cyberbullying. Beside all the mentioned laws, another legal framework that can be used to deal with cyberbullying is to use Section 506 of the Penal Code, which provides regulations regarding criminal intimidations. The threat of any injury to the victim with the purpose to harm the victim is a fundamental component of this crime. There are various acts that overlap and cover specific aspects that may or may not amount to cyberbullying within Malaysia's existing constitutional scope. But somehow, the existing legislation is insufficient to address cyberbullying offences as a whole. That's all.
So now we move to the next part, which is recommendations on how to improve cyberbullying provisions in Malaysia. Technology is improving every day as we live in the information and communication technology era. Aside from the positive effects of technology and the internet, one could use the latter to cyberbully and thus cause social problems. According to a new Microsoft Corp Global Youth Online Behavior survey, 33% of Malaysian children say they have been subjected to a variety of online activities that some may consider cyberbullying. As of October 2007, Cybersecurity Malaysia had received 60 reports of cyberbullying. Despite the fact that Malaysia has a number of provisions that address cyberbullying, cyberbullies frequently escape prosecution due to a lack of evidence. 625 cases of people making obscene or offensive comments via the internet or phone were investigated between 2009 and 2011. Only 16 were prosecuted and only 3 were found guilty. This is because the servers were located in another country and the prosecuting offenders was particularly difficult. Hence, the government and legislators should work on some recommendations and ideas on how to implement the legal protections against cyberbullying for school officials and the general public. The government of Malaysia should empower school districts to adopt bullying prevention programs that include classroom lessons on cyberbullying to ensure that students understand that bullying is defined as sending negative message or image to classmates over the internet or through cell phones. A school policy on anti-bullying can also be developed to determine the causes of cyberbullying and how to address the problem. A toll-free number can also be set up to offer advice, insight, and solutions to this problem. It is also suggested that specific cyberbullying legislation should be implemented. Section 233 of the Communications and Multimedia Act can also be suggested as the new laws foundation. The Ministry of Communications, Multimedia and Cybersecurity Malaysia should also increase its monitoring of adults and social media use and consider making it mandatory for users to register their social media accounts under their real names. This is because the existing laws such as the Communications and Multimedia Act and the Penal Code may not be enough to prevent cyberbullying. The government can also conduct public town hall style hearings via webinars and social media to gauge and engage for themselves the opinions, responses, feedback, constructive criticisms and suggestions from parents, ISP providers and civil society on what such a law would entail. It should be noted, however, that the Ministry of Communications and Multimedia is preparing a cabinet paper on anti-cyberbullying legislation. Malaysia has some cybersecurity legislation but no legislation specifically dealing with cyberbullying. In contrast, neighboring countries such as Singapore and the Philippines have passed anti-cyberbullying legislation. Malaysia had better have laws in place to deal with cyberbullying issues because things could get a lot worse. Regarding these recommendations and ideas to legislators on how to implement the legal protections against cyberbullying for school officials and the general public, it is hoped that the legislators could put in place appropriate policies and legislation. Parents, students, teachers, teenagers and IT users also hope will be well protected from cyberbullying.
So, I will continue with cases related to cyberbullying. There have been multiple cases of cyberbullying that resulted in teen suicide. The first case is Megan Mayer suicide case in 2006. Megan Mayer hanged herself to death after her friend's mother, Drew, disguised herself as a fictional boy on the internet and sent her an offensive online message stating that the world would be a better place without you. Drew was later then charged and convicted of violating the Computer Fraud and Abuse Act in 2008, which was eventually reversed on appeal. On the other cases, in 2010, Phoebe Prince committed suicide after being bullied in real life and through internet. Continuance from this case, the 6 teenagers were charged on a criminal offense consisting of statutory rape, stalking, and attack with deadly weapons. In the end, 5 of them pleaded guilty and charge for statutory rape against a teenage boy was aborted. In the same year, which is 2010, Tyler Clemente, a gay student, committed suicide after his roommate and his classmate videotaped his sexual intercourse with other men and then streamed it on the internet. His roommate was then convicted with 15 charges of invasion of privacy, bias intimidation, interfering with the evidence, harassing the witness, and intruding with the detention or prosecution. In May 2020, Artivia Nayagi, a 20-year-old Malaysian woman, allegedly committed suicide after receiving nasty messages on a viral TikTok video that made by her and a male colleague. Despite requests to the administrator of several Facebook pages to remove the video, as well as a police report that has been filed on May 16, it was reported that the footage remained on social media. The videos were not taken down from social media until her death, and Tivia's family is now seeking justice over her tragic and unexpected death. That's all.
Bullying is now visible not just on school grounds but also on social media and through the usage of mobile devices due to technological advancements. Since children are fully involved with information and communication technologies in their regular lifestyle, cyberbullying has become relatively common in every school. There are variations of existing law that occur to prevent cyberbullying at the same time to reduce the statistics of cyberbullying against kids or citizens in their countries. So, in this discussion, it will focus on the existing law among ASEAN countries such as Indonesia, Philippines, and Singapore. First, in Indonesia, cyberbullying with revenge and forgiveness being the most typical response to cyberbullying among high school kids. It is influenced by their Javanese culture. Cyberbullying is most commonly seen on Facebook, Twitter, gaming sites, phone calls, text message, and also email based on the statistics of UNICEF Indonesia. Children and teenagers aged 10 to 19 are active internet users who have been subjected to cyberbullying such as name-calling, abuse based on physical appearance, and online threats. It also highlighted that many schools do not yet have rules and restrictions in place for how much time students can spend online or what content kids can view. The Indonesian Electronic Information and Transactions Law Act No. 11 of 2008, according to the Ali Budiarjo Nugroho Reksudiputro ABNR website, provides a general law on cyberbullying, but it does not approach the kids. The lack of formal law, the government accepts the United Nations Convention on the Rights of the Child and the Child Protection Law. According to the UNICEF, schools are dealing with the problem by offering school counselors and enforcing strict policies on the use of computers and cellular phones on campus, such as limiting access to social media and limiting internet access time. Next, in Philippines, the Philippine Official Gazette, it has mentioned cyberbullying among kids in the Republic Act No. 1627 or the Anti-Bullying Act of 2013. In Philippines, it's supposed to develop and implement policies that resolve the issue using particular resources as a reference. The law also outlined what should be done if a school detects a cyberbullying incident. Failure to comply by school administrators will result in punishment, and private schools operating permits will be suspended. A year since the law was enacted, a news report revealed that 60% of cyberbullying complaints in the 2013 until 2014 school year were handled but not include cyberbullying. In 2015, 80% of Philippines youths aged 13 to 16 still face cyberbullying. Then, the parents are required to participate actively in their children's digital experience by developing ethical ideals in kids.
Now let's take a look on the approach of Singapore. Bullying was found to be common among students in Singapore's primary and secondary schools. Cyberbullying was found to be the least common one, but it's something that needs to be worried about also. The Singapore court held that bullying is not a legal term of art, which means that a victim of bullying does not have any legal remedies based on the occurrence itself. However, there are civil and criminal remedies for acts that equate to bullying. There is no particular cyberbullying law enacted in the country that concerns students, but there is a general law that handles it, which in 2014, Protection from Harassment Act came into force. The bill's purpose is to officially legalize harassment that occurs in cyberspace. Section 3 and Section 4 of POHA contain substantive provisions that make it illegal to use threatening, abusive, or insulting remarks or messages via the internet that cause harassment, alarm, or distress. Offenders may face a fine, jail, or both. To be charged with harassment, alarm, or distress under Section 3, the victim need not personally perceive or hear the unpleasant words or behavior. As for the unintended conduct, Section 4 covers it as long as the victim aware of it and it is objectively likely to cause someone annoyance, alarm, or distress. Even so, among kids, Singapore's Minister of Education took a proactive stance by asserting that all forms of bullying are prohibited in the country. Schools actively monitor the school climate and discipline and address bullying situation through educational, preventive, and intervention approaches.
For the part overall comparative analysis, only the Philippines has enacted cyberbullying laws that specifically addresses students. General laws are the only laws that can be applied to cyberbullying cases in other mentioned countries. And considering the absence of a cyberbullying law for minors, the governments have launched many anti-cyberbullying programs to tackle these issues. To summarize, cyberbullying has extremely negative consequences for individuals. It disrupts schools, causes significant emotional harm, and has the potential to be fatal. Both the bully and bullied are negatively affected by cyberbullying. The first and most serious consequences of cyberbullying is that it can lead to death. Many children have committed suicide as a result of the depression caused by cyberbullying due to their failure to report to adults and the appropriate authority figure. As a whole, all parties play a very important role in ensuring that cyberbullying can be dealt with properly. Cybercrime should be identified, prevented, and responded to in schools, according to school administration, and parents also must assume responsibility for their children's safety. Teenagers, on the other hand, should also take the first steps in preventing cyberbullying and cybercrime.